Everyone, good morning. Thanks for coming to another business law breakfast. This morning we're talking about business law structures. We've got Julie Maxfield. I'm a principal in the commercial and property team at Aiken Partners. I'm not going to keep you very long today because there's a fair bit to go through. We are keeping things quite basic in various areas because there is a lot to touch on. We've got three great speakers today. Two new people in the commercial and property team, Ralph Davies and Lauren Woolley, and Mike Chenoweth. He's been around a little while. They're going to navigate through the various issues relating to business, including business structures, getting things started to operate your business, and lastly, Mike will touch on the unfortunate topic of what happens when things go wrong. Just a few pieces of housekeeping before we get going. We're happy to take questions throughout the presentation or at the end of each topic. If you are on the webinar, use the Q&A function in the chat. And the bathrooms are through the doors and to the right where the lifts are. So first of all, we've got Ralph Davies speaking this morning. Ralph recently joined Aiken Partners and is in the commercial and property law team. Ralph is going to start by going through a background to the various different structures available when setting up your business. So welcome, Ralph.
All right, thank you, Julie. Good morning, everybody. I know a lot of people have had an early start today, so I'll keep you all very interested in the riveting area that is commercial law. So, as Julie said, I'm just going to go over four main types of business structures in a very broad sense. Any other questions, I'll answer at the end. So, to begin with, we have a sole trader, or also known as a sole proprietor. So, simply put, a sole trader runs their business as an individual. The structure is often used for small-scale operations, for example, tradies, hairdressers, and business consultants. Now, with this structure type, there is no legal distinction between the person running the business and the business itself, which means the owner is legally responsible for all debts and liabilities incurred in the management of the business. Now, going to some pros and cons. The first and potentially biggest pro is control. So you'll have full control of the assets and business decisions, meaning you won't need to compromise your visions with any directors, partners, or other personnel. Logically, because you have full control, you also have full ownership over any profit arising from the structure, meaning it can be quite lucrative. And the setting up of the structure is also very, very easy. You will need to register for an ABN at bare minimum and GST if your income is above $75,000 per year. Now, you can register for a trading name of ASIC if you want to operate the business as something else other than your personal name. And other than that, your personal tax return will be sufficient because you'll be using your personal TFN for this business type. And logically as well, there'll be minimal reporting obligations for the structure. You will need to report your income in your individual tax return, and you may be required to lodge business activity statements again if you do register for GST. As I'm sure you're not surprised to hear from a lawyer, there's obviously disadvantages to this structure type. The biggest is the unlimited personal liability aspect. As I said before, there's no legal distinction between the owner themselves and the business type. So any debts and liabilities incurred, creditors will come after your personal assets. And finally, you will have restricted growth. So seeing as you can be the only person to own this company, you can't split the responsibility with anybody else, meaning you can hire employees if you need to, but in terms of responsibility and sharing the burden, you'll need to choose a different structure type, which logically brings me to partnerships. So, simply put, a partnership is a structure with two or more people with the common view of profit. Now, there are three main types of partnerships I'll briefly go over. I'll be spending the majority of my time on general partnerships, but I'll just go over the differences quickly for you now. So a general partnership is where partners shoulder equal responsibility for the business, with each having unlimited liability for the debts and obligations that their partnership will incur. This means if the partnership's assets are insufficient to satisfy any debts, creditors will come after the private assets of the individual partners. The second type of partnership is a limited partnership. Now, this is quite similar to a general partnership. However, the key distinction is that it also involves what's known as limited partners. Now, a limited partner is an individual who will put assets towards a partnership, but they have no role in the day-to-day operation of the partnership. That remains with the general partners, and the general partners will remain sole liable for all debts and liabilities incurred. A limited partnership, the limited partner's assets are limited to the amount of money or assets that they put towards a partnership, meaning they're protected in that sense. And finally, there's incorporated limited partnerships. Now, this structure is a special incorporated form of limited partnerships, which is primarily established for people engaged in high-risk venture capital projects. Now, this organization requires at least one general and one limited partner with more onerous obligations and reporting requirements than a general partnership. Now, moving on to the pros and cons, again, I'll be mainly focusing on a general partnership when I refer to these. So first and foremost, it's quite easy to set up with low establishment costs. The reporting obligations are also similarly minimal. You are also equally responsible with your other partners for the growth of the business, and by default, you also split these profits equally. So again, if you find you're restricted with your growth as a sole trader, your partnership is a logical next step. Now, the biggest con, again, is joint and several liability. Now, when I mention several liability, that means you will be liable for the actions of other partners. They are essentially an agent of the partnership. So if your partner goes and incurs certain debts that the partnership can't satisfy, the creditors will also come after you. So it's quite important that you trust your partners who you deal with. Partner disputes as well will be quite problematic, seen as the decision-making abilities of this organization is in a very small group of people, meaning some action can be deadlocked if you can't come to a mutual decision. And finally, this partnership is quite difficult to transition, seen as partners will often put their personal assets towards a partnership, meaning if one dies or retires, the other partners may have to buy out those assets, and you can't just transfer the partnership over, and it's not a separate legal entity. Which brings me to arguably one of the most common forms of corporate structures, which is a corporation. So, the fundamental difference between a corporation, a sole trader, and a partnership is that in this instance, from a legal perspective, a corporation is a separate legal identity. So this separate legal personality means that setting up this organization is more complex and costly. Also, running this structure requires your understanding and compliance with all obligations under the Corporations Act 2001. And I'll come to that in a minute to see why that's important. Now, the rules governing a corporation are also contained in the company's constitution, which you can refer to as a manual as a direct on how to run the business. Now, the ownership, again, is impersonal, seen as it has a separate legal personality. Rather, the shareholders are classified as the owners of the organization, while the directors control the business operation and day-to-day management. The money made by the structure belongs to the company itself as its own legal entity. Therefore, this will give rise to company tax obligations that must be complied with. Some examples of obligations include annual company tax returns lodged with the Australian Tax Office, director declarations of solvency, and the completion of annual reviews each year. As you can see, this structure is quite favorable for high-risk businesses. Now, moving on to one of the biggest pros is the limitation of liability. So there is a silver lining to all of this administration. Directors have limited personal liability when acting on behalf of the company. Now, therefore, their personal assets are not usually at risk from creditors. Now, I say usually because you must be aware that if the director commits an offense under the Corporations Act or has been found to negligently perform their duties, they may be found personally liable, which is why I stress the importance of knowing the Corporations Act 2001 back to back. The reporting obligations and regulations mandated for this company will also bring inherent legitimacy to your business. Now, this can lead to enhanced trust amongst your consumers and your suppliers. And raising capital as well with the structure is easier than other structures, seen as a corporation has access to alternative capital raising avenues such as venture capitals or angel investors, which are only available to corporations. So again, this can assist in the growth of the company. The transfer of ownership as well is a big pro. Seen as the company is its own separate legal entity, if a director dies or retires, no assets need to be transferred across or vested in the new director. This transition can be managed internally. Moving on to the decision-making elements of this corporation. The decision-making powers will inherently lie in a small group of people, like a board of directors. Now, voting on major decisions in this structure does not usually require unanimous consent, like often required by a partnership. Now, this will logically reduce the risk of deadlocking any particular courses of action. Now, arguably the biggest con, as you're all probably aware of, is the enhanced reporting obligations and the costly management that comes with that. So the reporting obligations will result in higher costs incurred in the day-to-day operation of the company, and these costs will continue to increase the larger the company grows, which means you'll probably need to outsource specific elements of the company, hire finance managers, etc. Shareholders' rights is also a fairly big con for the reason that you need to be acutely aware that shareholders aren't just a vehicle for ownership for the company. You need to be aware that they have their own rights and entitlements, which you will need to respect as a director. Failure to respect these entitlements, again, can incur personal liability if you're not careful. And finally, as I mentioned before, the management of all of these obligations can be quite onerous and costly on directors and the company itself. All right, now we're moving on to the final structure, which is a trust. Now, essentially, a trust is an entity where trustees own assets for the benefit of beneficiaries, creating what's known as an equitable relationship. Now, these entities can be used in a commercial context for the reason that these business assets can be protected for the ultimate benefit of these beneficiaries. So there are two main types of trust structures that I'll go over. There are other structures that you may be aware of, but for the purpose of brevity, I'll just focus on discretionary trusts and unit trusts. So a unit trust is known as a fixed express trust. This is where the trustee will explicitly identify the beneficiaries and their allocated proportion of units in the trust. For example, you could have two beneficiaries with each holding 50% of the units of the trust, therefore they're entitled to 50% of the trust's assets. On the inverse, a discretionary trust provides broad discretion to trustees as to how they want to distribute these assets. So there are no fixed portions. The trustees can dictate what amount of assets go to which beneficiaries. This also lets you have different classes of beneficiaries in the trust, such as primary beneficiaries, secondary beneficiaries, etc. Now, arguably one of the most important elements of this structure is the fiduciary obligations that a trustee owes to a beneficiary. Now, a fiduciary obligation is essentially a relationship of trust where they act on behalf of the beneficiaries and for their betterment. They have no ability they aren't allowed to profit from the trust, and every action they do must be for the overall benefit of their beneficiaries. Breach of these duties can result in personal liability incurring, which I'll go into more detail in a second. Now, going to some pros and cons. Arguably, one of the biggest pros, again, is limitation of liability, which you'll hear from us all morning. So, because a trustee's liability is generally limited to the assets of the trust, creditors don't usually go after the personal assets unless a breach of trust has occurred. Now, this liability can be further limited with a corporate trustee if you choose to do so. The second pro is privacy. So, in general, trading information in the trust is confidential. Therefore, there's less visibility on the activity of the trust where there usually is with other corporate forms. Beneficiaries are, of course, entitled to this information, but other third parties usually aren't. And asset protection. So, a trustee company may go insolvent when acting on behalf of the company, on behalf of the trust, but seeing as they have no interest in the trust assets, the creditors can't go after the assets of the trust, seen as it's solely for the benefit of the beneficiaries. So for some cons, obviously one of the biggest is the complexity of a trust. So you will need to set up this trust, which requires drafting what's known as a trust deed, which you can essentially image as the manual for a trust. Now, preparing this trust deed is quite a complex and costly exercise, often requiring professional advice. And we always also recommend you get financial advice on setting up the trust as well. Now going back to the fiduciary obligations element. So these obligations extend beyond the scope of a director's duties to a company. It's crucial that trustees act in line with their fiduciary obligations for the benefit of the beneficiaries of the trust. If they're found to incur liability due to a certain breach of trust, such as gross negligence or acts of dishonesty, they can incur personal liability. The reason being is that trustees by default have what's known as a right of indemnity from the trust. So this means if they incur financial liability when acting on behalf of the trust and there's been no breach of trust, they can be reimbursed from the trust assets. If you breach these duties, you don't have that right of indemnity. Trustee powers are also restricted to the trustee. So, as I said before, the trustee sets out all the powers and provisions in the trust, and any powers that aren't specified in the trustee, you can't act on. So, if you require the inclusion of any additional powers, or let's say there's a legislative change in trust law, you will need to get this deed varied. Otherwise, you can be found in breach of trust. And as, again, you all already guessed by now, running a trust is quite an expensive and costly exercise. It does require professional legal advice, financial advice, and most decisions that you make have to be recorded correctly to ensure that you haven't breached these obligations that you owe to beneficiaries. And that's a quick summary on business structures.
Thank you, Ralph. Does anyone have any questions for Ralph?
With the trust, is there a limited asset value or base to start a trust?
Start trust, no. So when you do establish a trust, you need to put a certain amount of money in. So for example, you could put $10 into a trust bank account, and then technically those funds are held on trust with beneficiaries. So there's no limitations like that.
Are closed-end funds typically in trust structure?
Sorry, say again.
Are closed-end funds typically in trust structures?
That's an excellent question, Julie.
Closed-end funds, I think that's a pretty specific question, which we're happy to talk to about afterwards. Yeah, that's probably not something that we're really touching on.
All right, thanks.
Okay, thanks, Ralph. Just quickly wrapping up, I guess, from what Ralph said, depending on, the goals of your business, size, tax, benefits, you might consider all of the different structures. So that's definitely something that we can help you with moving forward. Our next speaker is Lauren Woolley. She recently joined Anchor Partners, also in the commercial and property law team. She's going to provide some background information on the matters that you need to consider when setting up your business. Thank you, Lauren.
Thanks, Julie and Ralph, for covering business structures. Like I said, I'm looking at some practical tips for once you've chosen your business structure and you want to get going. Alrighty, so first up is registration. So your registration requirements will be determined by which structure you choose. There's a government online registration system, so that'll ask you whether you want to register an ABN, an ACN, a business name, or a company name. And they request all relevant documents to be provided, such as what your structure is, the business name, address of the company, and any contact details. If you've decided to establish a trust, as Rolf said, you'll have to have a trust deed, which sets out the terms and rules for creating and managing the trust. Alrighty, in the list of things required by the government is a business name, which will be important to your business, as it's the branding and one of the first things your consumers will see. So it's essential that you get it right. One important step before registering a business name is to ensure it's not already being used and that it's not trademarked. If you're operating under a name that is already trademarked, you may be sued and cease use of the name. This can not only be disappointing if you've fallen in love with the business name and really want to use it, but it also can be costly because you now have to redo all your branding and possibly registration. If you have checked and there's no existing trademark with your intended business name, it's important to note that going ahead and registering the business name doesn't give you exclusive rights to use that name and stop other people from using it. If you want exclusive rights to use your business name, you'll have to register a trademark, which of course can be done to logos as well. Alrighty, the location of your business. Where you operate your business from will depend on what your business is. You need office space, a retail space, or a warehouse. Once that's determined, you need to decide whether you want to purchase a property or lease. I'll start with purchasing. In most cases, buying vacant commercial property in Australia, you'll be required to pay GST. which is 10% of the purchase price, and you'll also have to pay stamp duty. There's limited stamp duty concessions or exemptions when purchasing commercial property. However, you can always check if there's an exemption that applies for your particular circumstance. For example, if you're purchasing a regional premises. A very important consideration is that the stamp duty is calculated on the purchase price plus GST, which I'm sure you all might have heard in the budget announcement that they're abolishing stamp duty for commercial properties, and it's being replaced with a annual tax that starts 1st of July 24. So that'll be fun. Another consideration is whether you're entitled to vacant possession of the property or is it being leased. If there is a fixed term lease affecting the property, you won't be entitled to vacant possession straight away, and therefore setting up your business, it can't start until after the tenant's gone. And the relevant lease, which you will have had at that point, will give you details on how to vacate the current tenant. Of course, when purchasing any property, you need to ensure the specific conditions of the contract and vendor statement are reviewed. And you as a purchaser will also have to do your own due diligence on the condition of the property, conducted relevant testing, surveys, and that your finances are in order in time for settlement. Okay, for leasing, it's important to determine whether you're operating out of a retail or commercial premises and you're signing the correct lease. This area can be contentious between tenants and landlords due to the impact of the Retail Leases Act, which provides several protective provisions for tenants that are normally unavailable to commercial lease tenants. These provisions, amongst other terms, include constraints on the tenant's liability to pay outgoings that have not previously been disclosed by the landlord, the prevention of a landlord for recovering legal costs and expenses incurred during the lease negotiations, and importantly, the inability of a landlord to recover land tax from the tenant. It can generally be pretty easy to tell whether you have a retail business or not if you're open to the public and you have consumers. The conditions of the lease should then be reviewed and negotiated, along with the landlord's disclosure statement, which will outline essential lease information. Other considerations you can have during this time are whether there's any options for further lease terms, whether it be a rent-free period, ensure you can operate your business within the permitted use, and what your contribution is toward the outgoings. Another area where disputes can arise is upon the termination of the lease around the nature of the make-good obligations and the standard that the tenant is required to deliver the property back to the landlord. Alrighty, so you've got your place. To get it ready for business, it's likely to need a retail fit out for the shop interior. The property may have some fit out already, however, there may be some custom elements that you might need to consider for the startup cost of your business, such as displays, benches, mirrors. Really depends on what your business is. And you'll also probably need equipment, a coffee machine, a printer, and you'll also have to decide whether you want to lease or purchase this equipment. And you should definitely plan well ahead before opening day to ensure that you've got everything you need to commence your business. Equipment, of course, can be expensive. It may be impossible for a lot of small businesses to buy everything they need up front. So equipment leasing is a great way to spread these costs over an amount of time. And you also have the added benefits of things such as annual maintenance or repairs through the leasing company. And there are a few things to be aware of when entering into one of these leases, such as the amount of interest you'll be paying, the amount to pay if you want to purchase the equipment once the lease is up, if there are any circumstances you can break the lease, and you may not be able to modify any of the equipment you have, which could mean you end up with outdated equipment. These contracts can often also include personal guarantees, so we suggest reviewing and negotiating these contracts as required. Purchasing obviously has a bigger upfront cost, but there are benefits such as the ability to resolve issues more promptly, and because you don't have to get approval from the leasing company. This relates to repairs and any replacement parts that you might need. Rather than ensuring you're signing a reasonable leasing contract, when purchasing, you should be aware that if you're buying second-hand equipment, that it meets any quality or safety standards and regulations. Which leads us into the licenses and regulations. At this point, you probably think you're ready to start operating. You have to ensure you've got the appropriate council leases and meet all regulations. The type of licenses you may need will depend on your business type, activities and location. All local councils will have a section on their website dedicated to registration, with information on what registrations you'll need to legally operate and what regulations you must follow. I'll use the example of a cafe within Melbourne, which apparently we don't have enough. In this example, you need to complete food registration with Melbourne City Council, which allows you to carry on a food business and ensures the premises meets a number of food safety regulations. As this business may also be serving alcohol, you need a liquor licence, and ensure that all staff behind the bar have responsible sets of alcohol licences. Like most applications, they take time to obtain. So again, recommend getting it all sorted well before you intend to open your business. And of course, in the operation of your business, you should be aware of all food safety regulations that you have to abide by. Generally, across all local councils, the registration types will be the same. However, always check with the relevant local council for specific forms and the process for registration. Alrighty, finally we've got your employees, because you probably need someone to help you run your business. When employing staff, you must ensure you meet the standards and requirements of the Fair Work Act, which governs the employment relationship. When hiring staff, there are a few things you need to consider, whether you're employing someone full-time, part-time, casual, or as a trainee. The type of work you decide on will affect your obligations to your employee and the government. As such, it's important to differentiate and make sure yourself and your employee are aware of their status, as this can affect things such as leave entitlements, termination notices, the minimum standards of which are established in the Fair Work Act. Similarly, you want to make sure you know whether they're an employee or an independent contractor. The test to determine this can be quite difficult, so it's important you make that classification straight away, as it'll affect tax and super and other obligations. Of course, another important aspect is their pay. The minimum pay rates can be found in the relevant award. An award sets out the minimum pay and conditions for a particular industry or occupation. You can also use an award to check the tasks and classifications of employees, work hours, rosters, breaks, allowances, penalty, overtime rates, leave and super. Once you have found someone that you want to hire, you're responsible for making sure they can legally work in Australia. If you're considering hiring someone for overseas, you must make sure that the type of visa they have allows them to work for your business, and this can be checked for free online. Similarly, depending on your business type, your employee may need specific licenses or qualifications to do their job. If they don't have them, you might consider hiring them as a trainee or apprentice and helping them get those qualifications. So if you really like them, you can help them get there. Some of you maybe want to start a small family business, which might be exciting to employ your children and everyone to be involved, which of course involves ensuring you meet child labour law. When employing your own child, you're exempt from rules surrounding age restrictions, hours of work, and rest breaks. We don't recommend just hiring your children for cheap labour. Parents or guardians have to directly supervise their child. So if you've just got someone else watching your child, these exceptions don't work. They also can't perform work during work hours, or in jobs that may be harmful to their health or safety or development and things like that. And I know you're all thinking this is pretty obvious. You don't hire, kids. However, in April, Muffin Break was hit with 360 charges of breaching these child labour laws, with the maximum penalty for each offence being around $18,400. Similarly, Red Rooster was charged with 355 breaches and Cold Rock 124. So it happens. Whether your employee resigns or you end their employment, you'll need to follow rules about dismissal, notice and final pay, which again, the minimum amount for time for termination notices are set out in the Fair Work Act. So there we go, you're open and ready to start operating.
Thanks, Lauren. Does anyone have any questions for Lauren?
With the change to yearly taxes over stamp duty, that's a pretty significant change. But does that apply to those that have already paid the stamp duty, or is it after a new transaction happens?
Yeah, so I've had a bit of a look. I can't say I'm an expert, but yeah, so once the new sale of the premises happens, so if you've already paid your stamp duty, double. But as of the 1st of July next year, once you purchase the property, that's when it will begin.
And that's different types of property in Victoria.
Just commercial, not residential.
Right.
Just commercial and industrial. And at the moment, we're unsure as to whether it will apply. We would expect it will apply to contracts entered into after 1 July 2024. Saying no?
Like, not.
Well, it might not, but it would be pretty unfair, I would have thought, if you've already entered into a contract and then you settle after 1 July and you get hit with the tax. But as I said, it's not necessarily the way that tax office likes to work. But I would have thought, and we've done some research in the past couple of days, but they don't seem to say whether it applies to when you enter into the contract or when you settle the property. So if you've already got a contract on foot that settles after the 1st of July of next year, then, that's watch this space, I guess.
Right. Because we discourage people from making those transactions happen to an extent, right?
I guess it depends on what the tax is and that sort of thing.
Yeah.
But obviously some people have already entered into that contract, so their circumstances are what they are, and that's not going to give them a right to get out of that contract. So they're going to have to just wait and see what happens. I think, and my understanding is from the State Revenue Office that the 1 July date is an estimated date at the moment as well, so sort of what happens.
With the child labour laws, why wasn't McDonald's charged?
Great question. They probably skirt the line of what's legal and what's not. But again, that was just what came up in the last couple of weeks. So I saw it, and probably matters a bit. Called for something.
Is that if they are younger than 14 years and 9 months?
No, so that's actually not a myth, but 15 is under 15 you can hire someone, but there are a lot more restrictions and regulations. So there has to be a particular not license registration you have to be able to hire someone, and there's limitations on hours worked and things like that. And then once you get 15 minutes, fair game.
And what's the legal age for children to finish school, the youngest age, to stop their education normally? Is it 15 or 10?
17.
17? There you go.
Like a 17-year-old.
Thank you. Thanks, Lauren.
Ready? Thanks.
Lastly, we've got Mike Chenoweth, who's a principal lawyer in Aiken Partners Insolvency and Litigation team, and Mike also practices in the area of business law. So I think, as I mentioned at the start, Mike is going to take us through some of the unfortunate issues of what you might need to do when things go wrong, and what the consequences of that when you're operating a business. So thank you, Mike.
Thank you, Julie, for that very kind introduction. Not used to that.
Nicest thing I've ever said.
I know. You're recording something. Right. Well, good morning, everyone. What happens when it all goes wrong? A bit generic, I know, and a bit broad. Given what's been spoken about by Ralph and Lauren, everything that they've raised and everything that I speak about shortly can be dealt with over probably the course of 3 or 4 hour different conferences for a particular topic. There's no way we can get into all the detail, but I will sort of just give a bit of a broad overview of some of the things that can go wrong, because part of your decision making when you are setting up a business, taking on board what Ralph and Lauren have said, is whilst you might be aware that there are some risks, you need to also know, well, what happens when those risks play out and what are the actual consequences. Don't panic necessarily, but it might mean that. But maybe not. So dealing with partnerships first. As Ralph said, partnerships generally is a bunch of individuals. So you can also play in sole traders here, because as Ralph said, sole traders, you act in your own capacity. Similarly with partnerships, you've got joint liability, joint personal liability. So unlike the corporations area, partnerships are all dealt with by separate state legislation, and Victoria is the Partnership Act 1958. There's a whole bunch of rules, regulations that deal with how a partnership can be formed, dissolved, how the assets are dealt with and distributed, what happens when what happens when things go wrong, what happens when things are going well. One of the things you do need to be aware of with partnerships is that they're, notwithstanding what Russell also said, I have seen instances where you can have this in court informal partnerships. I've seen an incident recently where some well-versed corporate people decided to set up an entity to operate a business moving forward. 12 months down the line, they realised that notwithstanding a heads of agreement they'd signed, they hadn't actually set up the corporate vehicle. And what does that mean? Well, potentially that means there is some sort of partnership between these people, which then gets dealt with under partnerships regulations rather than the Corporations Act. It then gets into different issues about, well, the intention was to set up a corporation and therefore your liability potentially personally, but if that hasn't happened, has this informal partnership therefore incurred a bunch of debt which I jointly and separately liable for. So the biggest thing with partnerships, and I'll get back to this in a little bit, but the big thing you've got to worry about with partnerships is you do have that potential liability personally, and that can flow on to a number of significant difficulties such as bankruptcy. I'll get to that in a second. Shareholder disputes. This probably also touches on issues of trust disputes, but again, I could be here all day talking about and to be frank, I'll put you to sleep pretty quickly. But mainly, separately from the partnerships law, separately by the Corporations Act, as well as general law, can often involve issues of oppressive conduct against the company or shareholder generally. It doesn't always necessarily need to be oppressive conduct. There can be some oppressive conduct by majority shareholders, but it's implicated by the minority shareholders against the majority shareholders, which is pretty rare. Usually it is a group of people who are prejudicing or allegedly oppressing a minority shareholder. It can also be against the company itself. So, for example, the directors might be taking steps to operate a company in a particular way that a shareholder, which is a party, doesn't, or shareholder doesn't approve of. The relief that you can seek here is varied, but primarily three main areas. One which is injunctive relief, and that can be either an application to the court that says, I want someone to stop doing this, that is, you're prejudicing me, you're oppressing me, you're doing all these sorts of things, or alternatively, you're not doing these things and I want you to do it. So it can mean anything, it can be, there's a whole bunch of things that could mean, but that's generally what would happen there. Obviously, we're talking about injunctive relief, we're talking about court applications, so we're talking about very expensive bits of litigation potentially. Where we're talking about oppressive conduct against shareholders, typically the next two options are really what happens. So either there will be a shareholder that says, you're doing these sorts of things and I don't like it, and therefore I want you to buy my shares. Or alternatively, I don't like what you're doing and I want to buy your shares. The difficulty with these sorts of matters is that you need to engage experts to determine what the value of those shares are. There can be all sorts of things about not just whether the value of the company, and there's all sorts of rules about how shares can be valued. It can include, for example, just the shares and the value of those shares as against that company. But as you can probably appreciate, where there's a family business, shares to a family member might be worth more to that particular family member, for example, than likely to you or I. And so that value can be affected in that way as well. The next part is if it all goes wrong and no one wants to buy shares and no one can agree and the court says, well, I don't know what the value is, which is unlikely to happen, we get to a point where this business can't continue to operate. It's a corporate divorce, no one likes each other, you can't carry on. The next step is the appointment of a receiver and a clerk, and we'll get to in a minute. That effectively means that a third party is appointed to manage the affairs of the company with a view to realising its assets and selling them down for the benefit of creditors and where relevant members. So what is bankruptcy? Now I plugged this from AFSA, which is the Australian Financial Securities Association, which is essentially the organisation that's responsible for conducting or operating bankruptcies in Australia. Bankruptcy is a legal process where you are declared unable to pay your debts that can release you from most debts, provide relief and allow you to make a fresh start. Sounds great. Not quite sure what it may mean. But in essence, bankruptcy is where you are declared insolvent or you are unable to pay your debts. Now, what is insolvent? You are insolvent when you are not solvent, which sounds a bit circular. But when you're not solvent, when you can't pay your debts, hasn't been afforded you. So what happens in bankruptcy is you have a third party that is appointed to your estate, and that is essentially and the main. There's a couple of different consequences of that. One of which, the main one, is that your assets will vest in that trustee. And what that essentially means is if you own a home, if you have shares, if you have cash, if you have mayonnaise hanging in the backyard, what you don't, all these sorts of things, the rights in that property vest in that trustee. So whilst, for example, if you own a property with you or your spouse, if you own that property and you aren't named on title, the interest in that property vests in the trustee. So whilst you might be named, you actually have what's called a better legal right in the trustee. The trustee can and will investigate historical transactions. Now, what does that mean? Unfortunately, we see it in the industry from time to time, probably a bit too often. People can go into business and they can see the writing on the wall and they'll say, I know what I'm going to do. I'm going to transfer my house from me to my spouse. And that's going to be fine because I'm going to do that and be in her or his name and no one can get to it. No, it doesn't work that way. Sometimes people can even pay the stamp duty or pay stamp duty with assert that there's been a proper transfer. More often than not, people just transfer it in name only with no consideration paid. Trustees empowered under various sections of the Bankruptcy Act to basically get in there and say, no, that doesn't work that way. We've transferred an asset for either undervalue or no value. It's a transfer to try to defeat creditors, and so therefore I'm going to want to do that transaction. So something to be really conscious of. I have seen people say to me many times, well, I've got no assets in my name. That actually doesn't necessarily make a difference either. For example, as a general concept, even if you are not on the title of your property, but your spouse is, if you're a co-borrower and you've gone on the mortgage documents as a co-borrower and you've made contributions because you earn money through your job and you pay that into the mortgage, that can be considered to be an interest in the property that can vest in the trustee. The trustee can get in there and start paying. So something to be really careful. You may need to pay income contributions. Now, it's a different sliding scale depending on time of year, essentially, because it's constantly going up. Also, how many kids you've got. So if you want to get out of paying income contributions, get busy, because you're going to pay less. But in essence, what that means is over a certain amount, if you are earning over a certain amount, you have to pay 50 cents on the dollar contribution to your estate. You may have to forfeit your passport, probably of no consequence to most people, but something people might have family and friends overseas, they might have other business interests overseas as well. Usually,
I got a question the other day from a client. Like, I know I have to surrender my Australian passport, but do I have to surrender my Italian passport? Do you have an answer to that question?
I don't. I would imagine, and I'm not a passport law expert, but I would imagine potentially the Italian passport is property of the Italian government, so potentially not. But in any event, the bankruptcy trustees usually get around that by not only asking for your passport, but if they think you're a flight risk, they push you on a watch list. I had one recently where I was acting for a trustee and the bankrupt has completely ignored us for 3 years, given us nothing, not responded to anything, and then, despite having no money, allegedly had booked a plane to New Zealand and was very disappointed when he turned up to the airport to be turned around. The other thing is that not all debts are released. It's a bit of a myth. People may think that when you go bankrupt, that's it, it's all done. I don't have to pay anyone anything else. All the debts get caught up in my bankruptcy, not necessarily. Things like some statutory fines, child support, so don't be a deadbeat dad, not pay your child support, that will carry on. HEX fees as well, carries on as well. So I've just included this just to give you a bit of flavour for where it's at. So this is obviously the historical bankruptcies. This is sort of both voluntary enforced bankruptcy and also other arrangements. You can see there in 2020 it fell off the cliff. That's because of any number of reasons, mainly because people were terrified of being seen to be awful and bankrupting people when you couldn't even leave the house. The ATO, which is a major driver of personal bankruptcies, as well, decided to sit tight on their enforcement action. There was also an increase in the minimum amount you can bankrupt someone for, as well as extra time for you to apply. So basically, it got to a point where creditors decided this wasn't an effective tool to try and recover money. Although, as the courts say, bankruptcy should not be used as a debt recovery tool. So don't do it. Again, just a little bit of a graph to see where things are at. I think the interesting thing there is to see the ATO and the amount that they are the creditors for. Right. Now, consequence of corporate insolvency, I'll try and go through this quickly, I think I'm going too long. The appointment of an administrator, slightly different from a liquidation. An administrator is where an independent person comes in and takes over the company for a short time, maintains the status quo so that investigations can be had to see whether or not there are what the best options are to get the maximum return for creditors. Now, that can essentially mean one of three things. After the short statutory period, the company returns to the control of the directors, and the directors carry on. Almost never happens. The company enters into a deed of company arrangement. That's typically an arrangement where creditors will vote in favour of accepting a cents on the dollar return. Sometimes not much. I saw one just last night actually where the estimated maximum return was 2.1 cents on the dollar. And then the other one is to place the company into liquidation if there is no deed of company arrangement proposal, or creditors ultimately say we're not going to take your 2 cents on the dollar. Liquidator, a bit more of a death knell, so that's when a company dies, for lack of a better phrase. Liquidator is appointed to come in and realise the assets and distribute those assets for the benefit of creditors and their members. Again, it sounds wonderful, but inherently it usually doesn't happen very often. Very, very rarely would you see a 100 cents on the dollar return to creditors, let alone a return to members. But again, similar to bankruptcy, liquidator can investigate if there's, so going back to what Ralph said, typically in the corporate sense, a director doesn't incur personal liability, but if they are seen to have traded whilst insolvent, transacted in a way that was unreasonable, breached their duties as director, they may nonetheless be personally liable for their role in being a director of that company. Just a couple of small tales, and I'll rip through this pretty quickly. Again, just out of interest, we had the bankruptcy one before. This is the corporate side of things. A lot of corporate activity up until, and you've got to bear in mind this part here too, was only really half a year because very, very little actually happened in the first half of 2020. Fell off the cliff, is now starting to increase just a little now that people start to get back to regular programming. And again, you can see from these graphs, slowly but surely, there is a bit more enforcement action happening, and also people being forced to take steps. I only include this just for interest. Last year and this financial year, you can see the huge difference in particular the construction industry. Obviously, it's always in the news. In almost all of those stats there is an increase this year from last. Now, just finally, what's to do if things go wrong? Not this. Despite what you might think they are not my legs. Short answer is don't do nothing. The important thing is that if things are looking like they're going wrong, reach out and get the advice from your professionals, accountants, lawyers. This is what's happened when things do go wrong, but things can be done before they actually do go wrong. You should be engaging early with your financial advisors, accountants, and your lawyers if you start to see that perhaps you're entering into some trouble. And likewise, if you do actually get into trouble, the best thing is to speak to people and get some professional advice. The flip side can also happen. Not if it's just happening to you, but it's happening to some of your suppliers or creditors or business people. What I've just said applies to them. but there's also implications for you which you might be able to deal with. So I've spoken way too long. It's too much debt instruction for this morning. Any questions?
Once again, thanks everyone for coming this morning. Hopefully that was useful. As I said, it was pretty at a basic level somewhat. So feel free to reach out to any of us with any questions afterwards or by email. Our next business law breakfast, I think, is on the 22nd of June. Topic TVA, which will be coming shortly, so stay tuned for that. And yeah, feel free to stay around and have a chat afterwards. And we hope to see you next time. Thank you.